characters to do that. All right, we'll just do.
Okay, all right, we're live now.
Hello, happy Thursday. I feel like I've missed everyone. It feels like it's been a while. Maybe it's just been a really long week.
Yeah, there's a lot going on. And yeah, we were here a week ago, so it hasn't been too long, but
too long. So
yeah, so we'll be here every week, really.
We will. And your classes went live this week.
Yeah, we started on Monday. So we have 3 classes now recorded and up in the members area. And it's all about case strategy. And what I did was I gathered like all the different statutes that come into play on, property division, spousal maintenance, parenting plans, child support, enforcement, modification, for each topic, and then gave you the whole big picture. So I got really amazing feedback. We're like, oh my gosh, I didn't even know those, laws existed. This is so helpful. Thank you. So it really did. I got some really good feedback, and, we'll just keep making things better and better as we go along.
That's super exciting. I love this. I love the mission. I love the idea that we can make law more acceptable or accessible to people who don't go through undergraduate and then law school. So it's super exciting. And I'm so happy to be partnered with you on this.
Yeah, definitely. So how are things going for you? You've been doing some planning and getting the new year going?
Yes, things have been great, really great. I feel like for me personally, like 2022 was super chaotic, and 2023 is just feeling so much like less chaotic, so much calmer. And so that's exciting, like really exciting. My personal co-parenting relationship has never been better, and it's not new, right? I've been divorced since 2019, but this is an ongoing, evolving relationship, and you're never done. And it's really great because we had a super high conflict divorce. It took forever. It took 1,000,000 years, and it's never too late to get better. It's never too late to impact that relationship in a positive way. And that's exciting and wonderful and really good for my kids.
I would imagine things are constantly evolving as your kids are getting older and different things are coming up. And then each of you get less attached to each other, in your own new relationships and stuff. And the whole dynamic is finally ready to shift.
Right. Absolutely. And it's taken years. And my ex-husband's new wife has been an absolute gift to the whole situation. She is wonderful.
That's awesome.
Yeah, absolutely. So lucky. So lucky. So for anybody who's new and joining us, this is Julie LeBenz. I'm Billy Tarasio. We're family law attorneys in Arizona. We're doing a Q&A every week. We go live with inside our Facebook group, Decode Your Divorce support group. We're so happy that you're there. We're also live on TikTok, but if you want to ask questions, it's usually easier if you join the Facebook group. We will try to get to your questions. And the way that we do this is we are going to cover a topic, and then we're going to do Q&A. Julie, you're really good at the disclaimers. So you want to explain all those?
Yeah. So first of all, by participating in this Q&A or watching us, neither Billy nor I become your lawyer. I mean, I think that's pretty self-explanatory, but this isn't enough. We would have to, talk to you, enter into a client agreement. There's, more official steps to actually being your lawyer. Also, the information that we give today during the Q&A is just information. That's it. To give actual legal advice, we would need to sit with you, read your papers, talk to you, get the whole picture to actually advise you. And that's not what this format is about. This is more just information about the process and the law and some potential options people may have. And this is based on Arizona law. Both Billy and I have been licensed to practice law here in Arizona since, around 2005, 2006. So we've got a ton of experience, and we are going to talk about just, these questions from the Arizona law perspective. I have gotten some people send in questions from other states saying, hey, can I do Win Without Law School? And each time I've responded the same. I've said, look, there's going to be some concepts that will be helpful no matter what, but this is specific to Arizona. And so it could get confusing for you if you're learning about Arizona and then trying to apply it in your different state if the laws are different. So, keep that in mind. This is Arizona based, but there's 50,000 or so family law cases filed each year in Arizona. And, there's two sides to every case. So there's a lot of people in Arizona that are needing this help and information.
Absolutely. And I would say it cannot hurt you to get this information. If you're representing yourself in North Carolina, it is not going to be exact. But if you learn from Julie the statute that we have on property division, now you know you need to go look in your state for that statute on property division. And it's sort of the difference between when I've had lawyers join my firm who have practiced family law in other states, they pick it up so much faster than somebody who's never practiced. So the information that you can get in Win Without Law School will, just like you said, it's not going to be 100% specific to you. We are talking about Arizona law, but the information you will learn, I have no doubt, will make you better able to represent yourself no matter where you are.
Yeah, definitely. So today for our live, we're going to talk about how to prove that your ex is lying in court. Wow, this is a really big topic. Of course, who knows what the lie is going to be and things like that. But it's really important. And if you can prove it, wow, what a big deal that can be to the judge. I mean, if somebody's credibility is just completely destroyed, often the judge will make findings in the final order about that. And then that gets carried through, future, in the case, because let's say your case gets sent to a different judge. Well, what are they going to do? They're going to go back and read the underlying order. And if they see in there that there's a finding that one side lied, well, then in their mind, they're already, oh, well, that side's a liar. So proving it can be very helpful and can have lasting impacts, but keep in mind, what you think is a lie and what the judge thinks is a lie may not be the same thing.
Yes, this is a hard, it's important to prove somebody's a liar. And at the same time, if you've listened to our topics, you know that you can't rehash your marriage and it's a no fault divorce state. So you don't want to prove that your ex is a bad guy or a bad spouse, or that can't be the goal. So choosing which lies should I focus on in terms of showing the judge that there's a lack of credibility can be a hard question. What do you think about that?
Right. We're looking at lies outside the courtroom, something that happened before your trial. And who knows, that could have been a year before, it could have been 2 weeks before. I mean, who knows when the lie or lies actually transpired in conjunction to when you go to trial. And then there's being in the trial and listening to testimony and think, oh, they just lied on the stand. And so you've got two types of lies to potentially bring forth. And the lies outside the courtroom, just like Billy said, there could be hundreds of lies from your point of view, but what's really important for the judge? And I would say lying about money, because we have a waste statute in Arizona. So if you're concealing, hiding, disposing of property, and then you're lying to your spouse about it, that the judge is going to want to hear about. And that can be really persuasive. Also, lies related to your children. You're looking at best interest standards. There are some points in the law that talk about how one parent is affecting the moral health of a child, which some of that can get really difficult to prove, but it is in the law. And if you're your co-parent is constantly lying to your child and things like that, that could be very confusing for a child, obviously, and could get the attention of the judge. But if it's just some bickering back and forth between the two of you, or if it's that you have different points of view, the judge isn't necessarily going to take that and run with it or find it even to be relevant, because the judge is hearing these things all the time. Oh, they're a liar and this and that. And so you really want to have some powerful evidence and not just something the judge hears all the time.
Absolutely. Absolutely. I'm gearing up for a trial now, and the client has a lot of things that she would like to use to prove that her soon to be ex-husband is lying, one of the things that I've sort of focused in on is if I can prove that he's lied to the judge and show that, that's going to be more meaningful to the judge than if I can show that he lied to her. Because in a marriage that's falling apart, I don't know. I think probably 95% of the time somebody's lied to somebody about something. But if you can show judge, you can't believe a word coming out of their mouth because they've already lied to you, I find that to be pretty impactful.
Definitely.
And so you could use that from, an RMC, a private or a previous hearing. And the way that you could do that is we've talked about depositions and how depositions are their testimony, and you can use that for impeachment. And really, when we're showing somebody's a liar, that's what we're doing. If you've heard the term impeachment, that's what we're doing. We're impeaching them. You can get a transcript of previous hearings, and that was their sworn testimony. So if they said something at the RMC or at a temporary orders hearing, and you can read that to them when they're on their stand at the final hearing, hey, do you remember on X date when you said think this, and this? And they'll say yes or no. And then you can show your other exhibit that proves they're lying. And that is the correct way to impeach someone.
And one thing that can be very effective that you may not have to do too much digging on is showing lies in an affidavit of financial information.
Absolutely.
And if child support or spousal maintenance or attorney's fees, if there's some really big contested issue where the AFI is a key document and the judges want, you file that AFI under oath. It is a sworn document, and a lot of people flub on them. And so if you can prove that, especially on income, showing that they're not being accurate with their income, that could be a very powerful lie to prove in court that the judge would find compelling.
Absolutely. That is a treasure trove of potential impeachment evidence. You can impeach somebody on their claimed tithing that doesn't match up with their statements, all of their claimed expenses, whether or not they have other sources of income. If they don't list a roommate's income or other income they get from other jobs. Now, most of the time, somebody's just going to say, oh, I'm sorry, I forgot, I messed it up, I didn't understand. And it really depends on the judge whether or not they buy that.
Yeah, I agree. But even if you don't convince the judge that the other side lied, you've still proven your point that their AFI is inaccurate and a different number should be used for income, for example, which that's still going to meet your overall goal, which is to get the proper amount of child support ordered. So I think you really need to be clear on what your goals are. Obviously, having that landslide victory where you prove they lied and the judge sanctions them, and that would be amazing. But if you fall short of that and instead you get $200 more per month in child support because you prove their income's higher, I would be very happy with that victory.
Absolutely. That's a fantastic point. In one of the workshops that we did to help teach LPs, you taught how to properly impeach someone, because there's a technical aspect to that. Would you mind going over that?
So let's think about when you're in trial. Okay. So, you either go first or second, depending on whether or not you're the party that initiated the current action. So if you are going first, you're going to testify and go through everything, but then the other side is going to get a chance to testify. And when they'll testify on direct examination, and then you get to ask them questions on cross. And this is where, if you're wanting to prove the lie in the AFI or a lie in a pleading or some other document or something that happened, this is where you need to set it up. Okay. You're going to need to have your exhibits ready and craft your questions to lead, to show the lie. And that can be challenging. You really need to sit down and think about it, because you can't ask the smoking gun question first. You got to set it up. And if you don't do it properly, it can all get flubbed and then you don't really prove your point. So think about that. And this again, we're looking at, are you trying to prove a lie that happened outside of court, or are you looking to prove a lie on something that was said during their testimony, and really focus on what you're doing? The other thing to be cognizant of is to keep your emotions in check. I've had so many hearings where I've been kicking my client under the table, being like, calm down, because the other side's testifying and they think the other side's saying all lies. And they're like, and my client's like, oh, I can't believe it. And doing all this like heavy breathing and stuff. And it's distracting. It's immature. It's the judge doesn't like it at all. So keep your emotions in check, because I can imagine how that feels. Like you feel like you know the truth, and then you're hearing this person under oath saying things that you think are total lies, and it does get you heated. But you're not going to win any points with the judge if you start getting really crazy in, you know, the chair at your table in the courtroom. It's honestly going to look like you can't control your emotions. And if child custody is at issue, the court's going to take note of that. Like, the court is looking for who is the responsible parent, who's the one who's going to share this child, act in the child's best interest, you know, rise above disputes between the parents. And if you're sitting there and you can't even control your emotions in the court, the judge is going to be like, I don't know if this person really is who they say they are. So don't lose your credibility in trying to prove the other side lied, because proving a lie isn't necessarily the most important part of your case.
It is not. I'm glad that you said that. And I want to like reiterate it. Proving that somebody is a liar is not actually what you have to show the judge to win ever. You have to, which is why we teach people to start with what you want, determine what you must prove to get what you want, and then that is what you build your entire case and testimony around. And then you figure out, where can I jab on the impeachment? Where can I jab on and you're a liar? Because let's say you go in and you prove that this person is a liar. If you have not met these other burdens, if you have not shown this other evidence that the court needs from you in order to find in your favor, you will not win.
Yeah. And I want to give an example, because I just talked about proving a lie through cross-examination, but you can also prove a lie through your testimony. So if the other side's testified, and I'm going to give an example, they say, oh, I don't use drugs. I haven't used drugs, in a year, I'm sober, everything's great. And then you take the stand and you're like, well, I found a meth pipe in your room a month ago. This actually happened in one of my cases. And the judge went with that. There's kids at issue. She didn't show a picture. She didn't have a backup witness. She didn't have a conviction for drugs, but she brought up 3 or 4 examples of where she had, from her perspective, proof that he was using dangerous drugs. And what's the judge going to do? Of course, ordered him to do a drug test and but you don't always have to have a document. You don't always have to have a recording or a text or something. Sometimes you can just get up there, and if you have evidence of endangerment to the child, sometimes your testimony alone is enough.
Absolutely. And that does come down to credibility. Who does the judge believe? If you have ever in the past in your court case exaggerated or not been honest on your AFI, let's say somebody proves that you messed up your AFI, when you go to say, but I saw a crack pipe, the judge is thinking, can I trust you?
Yep.
So everything you do in your case, you almost want to be, it's so difficult. You're walking a line between being understated and not exaggerating, especially women have to be careful not to have the judge have the impression that they are over exaggerating. And at the same time, you have to get information out. It's a tough balance.
It is a tough balance. And of course, when you're in the courtroom and in trial, everything moves so fast. There's so much going on, but this is where you just need to be clear on what your evidence is, what your requested outcome is, and don't get too caught up on whether you've won or lost based on whether or not you've proven the alleged lies or not. But certainly it is something important to spend some time on, to prepare for, and to try to prove, because there can be major benefits in your case if you can prove lying, either just getting that negative inference against the other party in the paperwork, possibly getting a better outcome, or maybe even getting an award of attorney's fees. Because if you lie on the stand, to me, that's unreasonable conduct. I don't have a case cite for that, but I don't see how a judge would find lying on the stand to be a reasonable position. So that can grant you legal fees as well if you're working with a lawyer.
Absolutely. So what do you do when you only have an hour to present a temporary orders hearing? You have to prove all the best interest factors, and you want to also prove a lie. How do you determine what to focus on?
So really, this is where you've got your questions for direct and cross-examination, and you want to really work with those to tee up what you want to try to prove. But if you're trying to prove a lie on cross-examination and it's going nowhere, you're going to need to move on, because you're going to eat up your time.
Right.
Sometimes that happens, you'll ask the question on cross and you don't get the answer you want. So you ask it again and you still don't get the answer you want. And you ask it again. And then if you're self-represented, you're often like, but you're lying. That's not true. And then it's like, but you don't get to testify when you're asking questions. And, now the judge is just like, this is ridiculous. Can we move on, please? So although you may plan and plan and plan, understand it may not work out the way you want. And there can be some surprises in the testimony as well. I mean, I've had that happen where I was thinking things were a certain way and I set it all up, and then the person testifies a completely different way. And it's like, oh, all right, well, there goes that, because now they've shown that they had a real, excuse or explanation for what happened. And this allegation of a lie just isn't compelling anymore.
Right. Absolutely. Knowing when to move on, I think is 100% key for sure. Let's see. We've got some questions coming in. Do we have any other questions? Well, let's just recap. How do we show someone's lying? You can show they're lying through cross-examination, which would require you to give proof, to put evidence in front of them that what they said previously is not true. That is probably the hardest technical way to show somebody's lying, because you've got to set foundation. You've got to make sure that whatever evidence you're putting in front of them, they have the ability to lay the foundation to testify that it's true and then admit that that's a lie. That is maybe, I think, the hardest technical way to show somebody's lying. Mm-hmm. The other way you can show somebody's lying is through your own testimony, or through other people's witness testimony, or through your own exhibits that you present and testify to during your time to present evidence. Did I miss anything?
No, I think that covers it.
Okay.
And really just focusing on, what is this lie? Is it just something between us, or is it related to property that's going to be divided in the case? Is it related to income that's going to impact spousal maintenance and or child support? Is it something related to the kids? He was drinking and driving and he's lying about it. He didn't get caught by the police, but the kids told me what happened and now he's denying it. That's relevant.
Yes, it is.
So
but
really,
let's take that example. So how do you make sure the judge believes you when it's he said, she said?
Well, all you can do is your best effort. But like we talked about earlier, when you start bringing up safety issues, the court's going to want to err on the side of caution. And so you may not prove a lie, but maybe you get drug testing ordered, or maybe you get the sober link where you have to, do the breath test before and after parenting time gets put into place. And again, that's a victory. If your goal is to keep your kids safe, then these are measures in that direction. So it's important to bring it up. You don't necessarily have to have video evidence or proof, but if you're coming in and saying, look, the kids got home from parenting time on X weekend and they were scared to death, they were crying, and they talked about this wild drunken car ride that dad took them on. I confronted dad about it and he denied it and called the kids liars. This is a problem. Dad has a history of alcoholism. He has a prior DUI.
Right. What are the other circumstantial facts that exist? Like if you're coming out of nowhere with, dad drank and drove with the kids, but no DUIs, no history of alcoholism, no, but instead, if you can paint the picture with this is how much money he spends on alcohol every month, this is the bar he goes to, these are the other people who've seen him drink and drive. Now you've tipped the scales.
Yeah. This is what happened during our marriage or when we were together. He would, get drunk every night, whatever the facts are. And give the whole big picture. And then the court's going to be like, oh, I'm not sure what's true or not, but I want to make sure these kids are protected and nobody, no kid should be subjected to drinking and driving.
Absolutely. Okay, let's get into our questions.
Just real quick, if anybody's interested in Win Without Law School, go to winwithoutlawschool.com. You can sign up there. We've got an email list. And also we have a special running this month, $297, a flat rate for the entire year of access. And that ends on the 31st of January at midnight. So if you're thinking about it, go over and check out Win Without Law School.
Absolutely. It sounds like it's going really, really well. And just a reminder, Win Without Law School gives you different classes each week, depending on what type of case you're in. A divorce case versus a custody case versus a modification or enforcement case or a child support case, right? Those are the four.
It's the three. So child support will be part of those. But yeah, it's either a divorce, an establishment, or what we call post decree or post order. So you've already gotten divorce or established custody, but you want to make changes or enforce part of your decree or order. We talk about that as well.
All right. First question. How can a non-custodial parent present a pattern of abusive behavior? Now the child is adversely affected. There have been 47 DCS reports.
Okay. Well, obviously those reports, depending on what they say, that would be helpful. And just on a side note, whenever you get records that are long, 47 pages is pretty long. You'll want to summarize it for the judge. A 1 to 2 page summary, the date, and maybe a quote from the document that, shows abuse, and have that out just to make it easy, not only for the judge, but also for you at trial to be able to testify to the highlighted portions that are really important. So keep in mind, anytime you have any sort of voluminous record or exhibit, you're going to want to simplify it and summarize it. So, you would think that alone, 47 DCS reports, depending on what they say and depending on what DCS has done, that sounds pretty compelling. Aside from that, getting kids in counseling can be helpful, getting some counseling records to see what a professional thinks about the situation and how the child's being affected. Documenting any abuse that you observe when there's a parenting time exchange. So, you get the kid after they've been with your allegedly abusive co-parent. Are you seeing bruises? Is the kid upset and crying? I would be documenting all of that stuff. And then also if there's any major change in the child because of an increase in abuse, like have their grades suddenly gone downhill? Are they now isolating themselves? Are they depressed? Like, has there been a change in the child based on the abuse? Because the best interests of the child standards are what the judge is going to be looking at. So the more you can focus on the child and how this is affecting the child negatively, hopefully that'll get the attention of your judge.
And I completely agree. And I also want to, this is impossible for us to answer because it really depends on the court history here. Have these allegations already been brought to the court? Are they brand new? If they're brand new, why haven't they been brought to the court? So I would highly recommend you get a consultation. If you are in Arizona and you can't afford one, you can come to our pro bono day. Our next one is February 8th. But I think this is the type of case where you really have to talk to a lawyer to come up with a plan.
Definitely.
Next question we've got is, I'm currently going through a high conflict divorce. There's a lot of domestic violence between us, sexual assault on his part. I obtained an order of protection. I'm struggling to escape the cycle and I started seeing him again. How bad is this for my case?
What do you want? What's your intended outcome? you're in this tough place because with the history of domestic violence and the abuse, number one, I would recommend you not be in a relationship anymore. It sounds like there's a lot of toxicity in this relationship. So going back seems like you're just repeating a pattern that hasn't been serving you for a long time. But if you have kids together, I can't remember if that was part of the question or not, but if you have kids together, you do have a co-parenting relationship that's going to unfold one way or another. So you're going to be a part of each other's lives. Do you have to have orders of protection and no contact orders in place forever? No. So I'm not totally opposed to people, deciding that they're going to dismiss the order of protection and start finding a way to communicate in a healthy way if both sides are dedicated to that. But if this is more of a manipulation, I'm going to be sweet and nice to get you back so that you let go of these orders of protection and maybe we don't get divorced because I think financially this isn't a good time for me to do it. There could be a lot of manipulation involved here and not necessarily a genuine effort to love you and rekindle your marriage.
I think these are very, very, very difficult cases. Very, very difficult cases. And so I just agree with Julie, like get support, go see a counselor and make sure you're making the best decision for you and your children. Because there's so much guilt, I think, that surrounds this type of relationship where you're a victim of domestic violence and you don't leave, and then you're blamed for not leaving and you're blamed for not protecting your children. But in family court, you're blamed for withholding your children. So I just don't envy you. It's a hard situation.
It's a hard situation, but after you put up so many boundaries and now going back, I'm not sure you're really in alignment. Because even if you do eventually rekindle things, it seems like there needs to be a little more time to do some soul searching and get some independence to decide what's really best for you. Because like I said, I'm hearing a lot of manipulation here.
Mm-hmm. Okay, let's see. This is a good question. My opposing party is $6,000 in arrears, but parenting time has now changed to 50-50 and I make more money. Could I end up paying child support?
You could. Yeah. If you have 50-50 and relatively similar incomes, there's usually that often results in a zero support order. But if one parent makes more than the other, and not just a little bit more, but significantly more, I don't have a number to put out there, but that can tip the scales. And then the person that makes more money can have a duty to pay child support, which is kind of frustrating.
Well, how does the arrears come into play?
So the arrears is set in stone. Once a child support payment is due and is unpaid, it's deemed a judgment. It's an arrears amount that's owed, and 10% interest starts accruing. Now,
so even if he owes her money, she's still going to be ordered to pay. Would it cancel each other out?
Not that I'm aware of. Maybe that you could reach some sort of an agreement to reduce the arrears in exchange for not paying child support. So you could reach an agreement to that effect. But I don't think just through the system that would happen, that it would be two separate orders that I think would coexist within the system.
Yeah.
Now, being the one that's owed the child support, you do have some options. You've got a bit of leverage because the person who is owed the support has the ability to forgive it. Mm-hmm. All or a part of it through what's called an affidavit. Mm-hmm. And so this is where you can start negotiating. Hey, look, ran a new child support calculation. It shows I would owe this much. What if I agreed to cancel out your arrears in exchange for me not having to pay child support for, however much time it would get to that 6,000 amount? That might be a great deal to make. And then it would just be a matter of properly getting it before the judge. So you do have some more leverage, even though you may feel like, oh no, I'm going to have to pay now. Like you actually have some negotiating room here.
And I think you could ask a judge to cancel them out for a certain amount of time. I agree with Julie that child support, it's required, it's in the best interest of the child, and a judge is required to put child support in place or make a specific finding that doing so would not be in the best interest of the child. So if I were going to take this argument to a judge, what I would ask that judge to do is I would say, look, if this mom would owe this dad, let's say it's $500 a month, I would ask the court, instead of having him owe her X a month and her owe him X a month, this is the amount that would be more appropriate. Or this is the date that child support should begin. And it's in the best interest of the child for them not to incur the $8 payment that both of them would have to pay to go through the clearinghouse, because that would be money not going to the child. And therefore, I think you could ask. I don't know if it would work.
Yeah, you likely would need to do some agreement where you forgive the arrears and then also agree that child support starts for mom on a certain date and get a child support order in place with that starting date. And then you could have it equal out, equal cancellation of the past versus equal cancellation of what would be owed. And then once that's all settled up, the child support could resume. And then maybe you'll be ready for another modification at that point. Who knows?
Right. A quick question that we can answer very easily: is an evidentiary hearing the same thing as a trial? Yes, it is. Here's another question. My ex and I only communicate via writing. He constantly says I'm a terrible parent and insults me. What can I do? We signed the final orders in September.
Some parents like to use My Family Wizard and some other co-parenting communicator apps because they have some features on there that either tone down or exclude that type of language. So you can look into some of those programs and see if you can if you're the one suggesting at this point, you likely will need to pay for it, because getting the other side to agree to pay for it, that might be a tough sell. So if this is something you really want, I would look into it, find one that's, lower cost, and then propose, we're going to now communicate through here and I'll pay for it. And then that can minimize the attacks. If it's bad enough, you could seek an injunction against harassment, order protection, and then, kind of say, look, you can communicate with me about the kids. There are some exceptions within the order protection, which is in our order protection mini course. I go through all of that in the mini course, but there's very specific rules within the Arizona Rules of Protective Order Procedure about how and when and what type of judge can make exclusions or exceptions within the order protection order for communication between co-parents about their kids. So you could potentially go and get that order and say, look, I'm feeling totally harassed by these statements. Look at all of these. A reasonable person in my situation would feel the same way. And I need this order because I don't need this type of communication. I've asked him to stop and he won't. And then you can go from there. So that's an option, but there's also a really great book called BIF. It's about co-parenting communications. And BIF stands for brief, informative, friendly, and I always forget the last F. Firm. So you can, I'd recommend getting that book. It's on Amazon. It's not expensive. And start reading through there, because that can also give you some really helpful tactics for how to deal with mean and rude and insulting messages.
And I think this is a great, it's a great question, because even though you signed the final orders in September, you're just not done. You're not done. Family law just keeps on going. And it's going to keep on evolving. So great tips, Julie.
Yeah. And I'm curious what she's doing when those messages come in. Is she engaging? Are they throwing insults back and forth? Is she ignoring that? Is she asking him to stop? And that's where the BIF book can give some tips about how to proceed. But sometimes using humor can be effective to show that, because why is the person saying these things? They're upset and they want to get under your skin. So sometimes if you can reply in a way that shows, I don't care what you think, and this is funny that you are this caught up with me, that you feel like you have to insult me all the time. You're obviously still obsessed with me. it's time to move on. You know, sometimes you can use some sarcasm and things like that to start being like, look, I'm not a victim of your words, and I don't care what you think. You can say horrible things to me, but that doesn't change who I am. And it really just shows that you're a crappy person, because why are you insulting your co-parent like this?
So I definitely lived this personally. And sometimes I would find myself doing exactly what Julie just said, you know, responding to the substance, calling it out. It did not work. It did not work. It just escalates somebody who's completely dysregulated. So if they are telling you what a terrible mom you are, as I was getting those texts. And I'm not a terrible mom. And I knew it. You know what I mean? Like, you know, in your mind, you know that this is ridiculous, that that's just absurd. They are hurting and dysregulated and out of control. And the only thing you can do is figure out how to protect yourself. So I agree with Julie that saying, I'm not going to tolerate this. If you don't stop saying these things, if you keep texting me things that are irrelevant, I'm blocking your number. And then do it. Block the number. I'll open it in 24 hours to see if you're calm. That's a good boundary to set. The other, if it's bad enough, you can absolutely go get an order of protection, and you can tell them this behavior is harassment. If it doesn't stop, I will get an order preventing you from doing so. That's also a pretty effective way to communicate. But, you know, I'm a lot of years out of that time. You know, we originally separated in 2017. It took 2 years to get divorced. And eventually it'll get better. And he won't be obsessed with calling you a terrible mom. He's just hurt and miserable. And he wants you to be hurt and miserable. That's, I think, what's underlying this. And I know it sucks. I know it sucks to like filter out these influences that are off. They're very harmful. Like when somebody tells a mom they're a horrible mom, like it's hurtful. Even if you know better, it's hurtful. I get it.
Yeah, it's hurtful. And that's really where it's important for you to really connect with yourself. And like Billy said, like, I know I'm a good mom. Like, you really need to build yourself up. And maybe you have a family member or a friend that you can go to that can remind you of those things, you know, like calling your mom and being like, Mom, am I really a bad mom? Because sometimes you need that reassurance, but realize that breaking the emotional chains between you and your ex, this is one of the biggest parts of divorce or custody, because you've created all of these patterns of how you interact with each other. And now that's all changing. And maybe you're ready for the shift, but the other side may not be. And really, you need to just start disengaging as much as possible and moving on with your life. Because if you stay engaged and you allow them to manipulate you emotionally, make you depressed, make you upset, then are you really divorced? Are you really separated? Or are you just in, you know, legally there, but emotionally you're still caught up in this relationship that's not serving you?
And text is the worst for this because it's rapid fire and it can really get you guys spun up. And so sometimes saying, I'm blocking this number, you're going to have to email me, is a very powerful way to get some reprieve from the text, the ding, 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 while you're trying to do parenting time or whatever.
Unless it's an emergency, you do not have to respond right away. You can wait 24 hours. You can wait 12 hours. And
I never had the self-control to do that. That was what my partner was always telling me to do. And he's really good at that. He's really good at like not, but I never had the self-control to do that. But it's true. Like there's nothing that you're not benefiting anyone in that rapid fire ever. So lots more questions. Joys of co-parenting. I will tell you also, it gets better. I don't know if you were here at the very beginning, but it gets better. And you have your co-parenting relationship will not be the same today as it is years from now. And everything you do on that journey will either move you in a more positive direction of co-parenting or a more negative one. And boundaries are healthy. Anyway, okay, let's do some other questions. So the one person said, what do I do if one party doesn't renew the co-parenting app, OFW, and it's ordered? Well, you can just continue to communicate in there and they will miss out on that communication. That's one way to do it. If you still need it. I would not recommend you go back and do a petition for contempt or enforcement, probably, unless, we talked about it and it was very specific to your case. Generally speaking, I would say you probably wouldn't want to do that.
Right. Or if you had more things than just that one issue
Right.
to enforce. If you had 5 potential violations of the order, then I would throw that in too, but I wouldn't go with just that one.
Here's a fun question. My 78-year-old father is getting a divorce, and she has sent money for years to her son who lives in Florida. Will a forensic accountant be able to find the money if it's in his name only? And I'm going to add, and will it matter? If you're in a marriage and one party is gifting money to their child, is that allowed or not?
What is the source of the money? Is it marital money or is it separate money? So I'm not sure how long these two have been married. But if the spouse sending the money, if this is their own separate money, then no harm, no foul. They can do whatever they want. So for example, if they inherited funds and then they were sharing those inherited funds with a child, that's totally fine. Now, if they were using marital money and giving it to their separate child, the next question is, well, was their spouse in agreement?
Mm-hmm.
Did they know about it? Were they agreeing to it? Because if everybody was in agreement, then again, no problem.
Mm-hmm.
On the flip side, if in particular they have a written agreement, which of course spouses rarely have written agreements between themselves, but if they had a written agreement indicating, look, I agree that you can use marital funds to go to your child, but half of that you owe back to me, and had terms about that, because, with marital funds, half is one spouse's, half is the other. So that could be an argument. I don't know if this would fit within waste. You could try to see if this is some sort of waste argument. I think if the spouse was giving money to their kid and that was causing financial problems for the marital community, that could be potentially compelling. But yeah, we need a lot more facts here. And there's a possibility that it's not compelling at all. In particular, what if the other spouse was giving money to their kids as well? There could be a whole balancing test here where everybody is getting money.
Right. The court is not going to go back and punish someone for mismanaging funds. So waste is hard. It's very limited. Very limited circumstances are waste. So choosing to spend money in a specific way that your spouse doesn't agree with is not waste, including probably gifting to your child, unless it was secret. And if you knew about it, but you were protesting, you're not like you're not preserving that argument to get repaid. A court's going to say, if it was unacceptable to you, you probably should have filed for divorce.
Yeah. Should have filed for divorce or made some changes to the accounts and access to money.
Right.
But yeah, a lot of times the courts will take that position. If you delay getting divorced or something, and then you have some complaints, the court will be like, well, you should have filed for divorce. Which is,
harsh. I get it. Deciding to end a marriage is not something you would take lightly. And maybe you weren't wanting to end your marriage over this gifting of the money, but you need to understand you're kissing it off. Like it's probably gone. You might be able to get it back. But anyway, my stepson lives 50-50, and he's been sleeping in a full-size bed with his mom and 2 toddlers in the same room for a while now. And before that, he was on the couch. It's a 4-bedroom house, and there's 13 people who live there. Can we take this to court so he can live with us? He has a room and a bed here. Bio mom has always lived with her whole family, so it's been years and years.
It's a tough one.
Totally.
It's a really tough one. The courts are going to want the child to have time with both parents, regardless of whether or not one parent can provide the optimal housing situation. So these situations are tough. I've seen judges find this compelling. I've seen other judges not.
Mhm.
So there is no black and white answer. It really depends on your judge and your exact facts. But
Mhm.
just the sleeping arrangement alone likely is not compelling. You likely need more to show that the sleeping arrangement is negatively impacting the child.
Right.
And then that could be grounds, but just the arrangements alone and saying ours is better, although it's decent evidence, I don't know if it's enough to change things.
I agree. It depends on what's going on in that house. If you've got 13 people who are like the Encanto family, everybody's all together in the house and they're all, eating dinner together. Like arguments could be made that that's a beautiful family arrangement just because it's different from yours. But in other cases, you've got crap on the floor, you've got random people sleeping there. Somebody was convicted of burglary 3 years ago. So it really depends on, I think, your situation.
Yeah. And of course, is there any inappropriate sexual conduct in these shared beds and things like that? That's where it can really get dicey.
Right. And it says he's sleeping in a full-size bed with his mom and two toddlers are in the same room. And we also found out he's 10. So if the mom is sleeping with the 10-year-old and the two toddlers are on, air mattresses or twin beds or whatever, it might be fine. And even the co-sleeping, some judges have a real problem with that. A mom and a 10-year-old, they would be like, that's absolutely not okay. They're especially not okay with it when it's a dad and a daughter. And some judges are like, people co-sleep. It's your call as a parent. So,
and also let's say your co-parent can only afford a 1-bedroom apartment. The court's not necessarily going to, take away their parenting time just because they can't afford a separate room, a bedroom for the, kid or kids.
right. Speaking about the affidavit of financial information, every time a judge ordered both parties present an AFI to each other, one party never does. It's brought up in the court and the judge ignores it or just glosses over it. What do they do?
So can you see this as an opportunity? A lot of people look, oh, they didn't do her. It's like, oh, they didn't do it. So guess what? I get to fill in the blanks for them. A lot of people don't see the opportunity there to actually control the evidence because the other side didn't submit any. And so that's where I would be like, okay, they're not going to show their income. Well, here, I just subpoenaed their pay stubs or, their tax returns, and here's their income information. And well, they didn't fill out the AFI, judge, so we don't get to consider their expense information. And, too bad for them, they missed out. I would more be trying to like bulldoze my position forward for what I want the court to adopt for the other side versus complaining that they didn't do the document.
I totally agree. And legally, I can't remember if this is a statute or case law or culture. So please help fill in the blanks here. If you fail to provide evidence that you've been ordered to provide, there is an inference against you and for the other party. So if I'm trying to prove somebody's income, let's say that the other party is a truck driver, I'm going to go on Monster or on Indeed and find the highest paying truck driver job I can come up with and say, judge, this is the evidence you have to accept because the other party failed to do so.
Mm-hmm.
So is that a law or?
Well, yeah, I mean, it's saying, and I think a lot of judges are open to that because so many of the judges want you to
follow the rules,
accurate AFI and follow the rules. So yeah, I would definitely be arguing, look, they shouldn't be allowed to present this evidence now. First of all, it's not fair to me because now I'm getting what's called trial by ambush. They should have given me the information ahead of time so I could prepare. I can't come into court and get it for the first time. That's an ambush. Right. And so that's not fair. And because they didn't follow the rules and we're here, in front of the judge right now, objection. I would be objecting to them trying to submit the evidence then. They didn't disclose it. It's late. They didn't do their AFI. And no, we shouldn't continue this to give them more time. That's their fault. And here's the evidence I want the court to consider, the evidence of income or pay stubs or whatever you have.
Absolutely. So bottom line, when the other side is not following the rules, figure out how to make this work to your advantage. That's your only option.
Yeah. Because you get to fill in the information.
how do I get transcripts from court records to help find impeachment? And another question related, how do you get copies of testimonials from a parenting conference?
Okay, so as far as getting a transcript or audio recording of a hearing, you make a request to the court. I usually do it by filing a motion with the court to provide me with a CD recording. And either they'll produce that, or if there's been a court reporter that's in the room, then they'll refer me to the court reporter to purchase the transcript from the court reporter, which can get kind of expensive depending on how long the court case is. But if you just get the audio CD, you're still going to need to have that transcribed or, put into writing in a valid way, because the court isn't going to sit and listen to an entire audio CD. Another thing is to look at your minute entries, see if there's anything in there that, has what you would want to get out of the CD, or if there's any court orders within your case that have that information. But that would be the way to go about getting a transcript of testimony from a hearing.
Mm-hmm. And what about a parenting conference?
I know sometimes some of that stuff is confidential. If it's not confidential, then you can ask, but I think you'd go straight to the parenting coordinator for that, because they would be the one in possession of the recording.
Yeah, when I read this, copies of testimonials, what I think that might mean is that the other party provided written evidence to the parenting conference provider. And if that's true, you should be able to get that written evidence, especially if they relied on it for their report. I think the parenting conferences are not private because they make a report to the court about what happened. But let's say it was mediation, then you would be unable to get any documents or any testimony, or because it's confidential. So you're allowed and encouraged to say things in mediation that cannot later be used against you so that you settle. So, all right, it is 11:56. You have a class coming up, a live class coming up.
Yeah,
so go, but I want to encourage anybody who's interested and likes this topic and wants to learn more to join Win Without Law School. Go over to winwithoutlawschool.com. We've got an annual price special going right now, and anything you may have missed is recorded and available to you. It is the best education you can possibly get without going to law school. Thank you, Julie.
Thanks, Billy.
Talk to you soon. Bye.